And look, there's a Michigan family that paid off their house, worked hard, raised their kids, did everything they were told was responsible. And one day, the county walked in over a $2,242 property tax bill and walked out with $194,000 of their home equity. The Supreme Court spent an hour 2 months ago deciding whether this license to steal is still allowed to happen in 5 states. You might live in one of them. And if you do, your county can take your paid off home over something as small as a $100 disputed tax bill. The government's own lawyer admitted it out loud, in court, on the record. And look, let this Supreme Court case serve as a brutal warning on your home equity, because the same machine that took the family I'm about to tell you about is sitting in your county right now. And you'll see what I mean as I quickly walk you through the case the court heard last month, why 19 states fixed this in 2023 and which 5 didn't, who's quietly pocketing the equity, and then the 3 things to do this week for less than a couple car payments that put your house outside the reach of any of it. The family's name is Pung. They live in Michigan. The story starts the way every one of these stories starts, with a property tax bill. In this case, $2,242. Now, here's the part the news coverage skipped. The Pungs didn't actually owe that tax. Years earlier, the Michigan Tax Tribunal had ruled in writing that the family's property tax exemption was valid. The county's tax assessor had lost that case in court with a written ruling. So what did the assessor do? Well, they went back and reapplied the same denial anyway. You see, under Michigan law, the same assessor can deny that exact same exemption again the very next year on the same grounds. The tribunal ruling only covered the years they fought. The assessor came back, denied the next year, and started the fight all over again with a new tax bill. The Pungs had 35 days to appeal the new denial. They missed it. By the time they realized what had happened, interest was running at 15% on a tax they had already proved they didn't owe. The county then foreclosed on the new delinquency, which means taking their house wasn't a clerical error. It was a conscious choice. And you gotta wonder why. Well, here's where it gets interesting. The Union Township tax assessor, the one who kept denying the Pungs exemption, was asked under oath in a later hearing whether she cared what the administrative law judge had ruled. Her sworn answer, on the record, "I don't care what he says." So it came down to one bureaucrat's personal interpretation, backed up by the county's foreclosure machine. To an outsider, it almost seems the Pungs lost their home for something personal. Actually, though, it's worse. Losing your home to a personal vendetta would be understandable. Crazy, but understandable. But they lost their home to something that would seem unfathomable in this country. They lost their home to one bureaucrat's stubborn belief that she was right and the judge was wrong. Unhinged ideology. Deranged ideology. The county itself had the home assessed at $194,400. That's the official county number. Yet they sold it at auction for $76,008, about 39 cents on the dollar. The auction buyer turned around and resold the home within weeks for $195,000. So the math, $2,242 in disputed taxes, $76,008 collected at the auction. The remaining $118,392 in home equity, gone. They call it tax enforcement. 2 sterile words to dress up the fact that a bureaucracy just reached into your pocket, took $100,000, and expected you to thank them for keeping the streets paved. And look, if you're thinking this is just a single freak occurrence in Michigan, and it's got nothing to do with you, think again. The Pungs got crushed by a chain of 3 things, and every single one of them, or a version of them, exists in every county in America. 1. A property tax law written almost 100 years ago that nobody ever updated. 2. A county that runs on revenue from tax foreclosures and isn't going to give that up voluntarily. 3. One local bureaucrat who decides she knows better than the judge. Pick any state, pick any county. Those 3 things are sitting there waiting. Michigan is just in the current spotlight, but it's not the first time we've been here. 3 years ago, May 2023, the Supreme Court ruled on a case, Tyler versus Hennepin County. Geraldine Tyler, 94 years old, Minneapolis widow, owed about $15,000 in property taxes that started much smaller and ballooned with penalties. Hennepin County took her home, sold it, kept everything. The Supreme Court ruled unanimously, 9-0, that what the county did was unconstitutional. 3 years before that, the Michigan Supreme Court ruled on a case. Uri Raffelli, 83 years old, retired Michigan engineer, owned his rental property free and clear. underpaid his property taxes by $8.41. One Chipotle burrito's worth of math error. Oakland County took the house, sold it for $24,500, kept everything. $8.41. That is a level of disproportionate vengeance usually reserved for a mob boss who feels disrespected, not a county tax assessor. And those two cases are the famous ones. Here's the scale of the quiet ones. Between 2007 and 2021, Michigan counties foreclosed on nearly 290,000 properties for delinquent taxes. One property for every 35 state residents inside a 14-year window. That's not an aberration. That's volume. They call it clearing the tax rolls. Sounds like housekeeping, right? What it really is, it's a conveyor belt moving quiet equity from the people who built it to the municipalities that squandered it. And just 2 months ago, February 25th, the same story is playing out again. The Supreme Court heard Pung versus Isabella County. During the hearing, one of the justices asked the county's lawyer a hypothetical. If the tax bill had been $100 instead of $2,200, would the county still have taken the family's home? The lawyer's answer? Yes. Yes, they'd still take a $194,000 house over a $100 disputed tax bill. That's on the record. Federal court. Oral argument transcript at supremecourt.gov. You gotta admire the sheer unblinking audacity, don't you? I mean, the lawyer stood in front of the highest court in the land, was handed a hypothetical so insane it was meant to be a joke, and essentially said, yes, Your Honor, we would absolutely steal that much money over a rounding error. Thank you for asking. But there's a technical question underneath all of this, and this is where it gets really interesting. The court isn't just deciding whether the county can take more than it's owed. They already ruled on that in 2023. The court is deciding how you measure just compensation under the Fifth Amendment when the county sells your house at auction for half what it's worth. That's exactly what happened to the Pung family. The Supreme Court is deciding whether the Constitution lets them keep playing that game with your house. They'll get the final ruling by the end of June. But here's the question nobody on the news is asking. Tyler versus Hennepin won unanimously in 2023. The Supreme Court told the entire country in writing that what the counties had been doing was unconstitutional. So why is the Pung family still in court 3 years later? Well, two reasons. The first one is geography. The second one is the part that should keep you up at night. 19 states changed their laws after Tyler. They put in surplus return mechanisms. They actually complied with the Supreme Court ruling, but 5 states didn't. Alabama, Arizona, Michigan, New Jersey, New York. About 51 million Americans live in those 5 states, roughly 1 in 6. If you live in any of them, the system that took the Pungs home is the system you're living under right now. And here's where this whole racket started. Most American tax foreclosure laws were written in 1933, 34, and 35 during the Great Depression. The exact statute the Supreme Court struck down in Tyler was a Minnesota law passed in 1935. The deal back then, it was simple. Counties got streamlined foreclosure powers because municipal budgets were collapsing. It was supposed to be an emergency measure. Emergency powers. Notice how the emergencies always end, but the powers never do? They sold it as a temporary fix to keep the streetlights on in 1935. And 90 years later, they're using it to strip mine retirees. We had 3 other Depression-era emergency measures alongside it. The bank holidays, the gold confiscation, the eviction moratoriums. All 3 got reformed when the Depression ended. Tax foreclosure never did. Home values then exploded. The 1935 statute kept running. By 2015, what was designed to recoup small tax debts on depressed Depression-era properties had become a wealth transfer mechanism on $400,000 paid-off homes. Nobody updated it. Nobody had to. The counties were doing fine. So here's the question everybody forgets to ask. The county takes the house. The county collects the tax debt. Where does the surplus actually go? Well, there's 3 levels to this. Level 1, the county itself. In the 5 holdout states, the surplus drops directly into the general fund. It's a budget line item. Tax foreclosure isn't just enforcement, it's revenue. It pays for road repaving and pension obligations. General fund. It sounds so benign, doesn't it? Like a municipal piggy bank. Well, it's not. It's a black hole where your 30 years of mortgage payments go to plug the holes in a budget they couldn't balance. Level 2, the tax lien investment industry. Yeah, there's a real industry with real names. Fund Recovery, JT Investments, Tax Title Services. They buy delinquent tax liens at county auctions and then earn 12 to 18% annualized yields. When the homeowners can't redeem in time, the fund forecloses and captures the equity below market. there's a multi-billion-dollar Wall Street side of this whole thing. The entire business model depends on home equity theft being legal in those 5 states. Imagine having a business model where your primary revenue stream is hoping an old lady forgets to check her mail during a hospital stay. That's not an investment strategy. That's the plot of a Disney villain's origin story. Level 3, and this is the one in court filings. Some of these foreclosed homes don't even go to public auction. In Michigan, Oakland County foreclosed on a family home, then sold it through a chain of legal transactions to a private company called the Southfield Neighborhood Revitalization Initiative, which was managed by Southfield city officials. The company resold the home for over $300,000. The government took it. Government's friends bought it. Government's friends resold it. Original family got nothing. And just like that, the equity is magically laundered. It's the municipal version of, I didn't steal your wallet, I just found it after my buddy knocked you out. I know that sounds like tinfoil hat territory, but that chain of title is on the record. Pacific Legal Foundation documented every link. You can pull the deed transfers from the Oakland County Recorder's office yourself. I've been in real estate for more than 20 years now, and investors have known about this game for decades. The homeowners who got blindsided are just the ones who never read the manual. So how do families with money never seem to get caught up in any of this? It's not because they have better lawyers. It's not because they're richer. It's structural. Sophisticated families don't fight the county at the courthouse. They make sure the county never reaches them in the first place. 3 layers, and none of it costs more than $1,500 or so, and that's if you splurge. Layer 1. The property isn't in their personal name. It's in a trust. The trust uses a corporate trustee or a paid mailbox at an attorney's office. Every notice from the county, tax bill, supplemental assessment, code violation, goes to a processing center with a 48-hour turnaround, not to a 72-year-old who's in the hospital recovering from a bad week. If you haven't done so already, this week, consider transferring title to your home into a revocable living trust. Get a consult with a local estate planning attorney, not just a will guy, a trust guy. Cost runs $400 to $1,500 depending on your state. The attorney drafts the trust, you sign a quitclaim deed, the deed gets recorded at the county. Suddenly, the county is no longer mailing notices to your mailbox. They're mailing them to a corporate trustee's processing center that notifies you when people like the tax assessor comes a-calling. And if you need a place to start, you can reach out to the people I use at protectwhatsmine.com. Layer 2. A homestead declaration recorded at the county recorder before any delinquency. In several of these 5 states, a recorded homestead caps how much equity the county can capture in a forced sale. Recording fee runs $20 to $80. Most homeowners don't even know it exists. So another simple move you can make this week, file your homestead declaration. Most county recorders have a 1-page form. Fill it out, get it notarized, pay the small fee to record it. 30 minutes if you do it in person at the county office. In New York, New Jersey, Michigan, and Arizona especially, the homestead declaration caps your equity exposure in any forced sale. It's the procedural firewall most homeowners have never even heard of. And it works a little differently in each state, so check your state specifically. Layer 3, automated monitoring. Either a paid registered agent service that scans county records monthly, or just the county's own email alert system if they have one. Most do now. The instant a supplemental assessment, lien, or a code violation hits the record, the trustee gets notified that day. 5 minutes. Tonight, log into your county tax portal, enroll your property tax bill in autopay, then find the county's notification settings. Most counties now have email or tax alerts for new filings on your parcel. Sign up for them. That eliminates the single point of failure on a mailbox notice that gets buried in a stack of mail during the wrong week. So 3 moves. Total upfront cost, under $1,500 or so. Total time, 2 days, 48 hours. The Supreme Court is going to rule on Pung before the end of June. The ruling could go either way, and even if it goes the way it should, history says the 5 holdout states will manipulate their workarounds, they'll exploit their loopholes, and just basically do what governments and bureaucrats do. The legal game, it continues. The defensive homeowner doesn't wait for any of it. That's what we call active defense. So the ball, it's in your court. 2 plays you can make. Play 1, keep paying your mortgage off, keep paying your property taxes, and trust your mailbox. And hope the next 10 years don't include a hospital stay, a death in the family, a missed certified mail notice during the wrong 6 weeks, or a county budget shortfall that turns your house into a budget line item. That's how the Pungs lost $118,000. Or make play number 2. Make the investment and move your deed into a trust. File the homestead, set the auto pay, be the family the county scrolls past when they're looking for a target. And look, once you put up that wall around your house, you're gonna start noticing something. The county isn't the only place where the rules were written for somebody other than you. Once your eye is trained for it, you start seeing it everywhere. Take Medicare as an example. If you're already 65 or you're staring it down, you probably figure Medicare is some friendly government safety net that's just going to take care of you when the time comes. Well, it's not. Same kind of system there, same kind of game. The Medicare bill that LBJ signed in 1965, that was 135 pages. Today, the rules and regulations are over 130,000 pages. And the same kind of middlemen who showed up to flip the Pung house at auction, they're the same ones running daytime TV ads telling you they're going to help you pick a Medicare plan. They're not helping you. They are commissioned salespeople pushing whatever plan pays them the most. Which is why I pulled this video out here for you to watch next. Same game. Eerily the same conversation, with many more landmines, yet totally avoidable. So watch this one now. God loves you, and so do I. Take care.